Good evening, friends. Jai Hind to all of you. Today we're going to start the Constitution of India. We'll be studying the Constitution of India in this Indian Constitution articles. So we will be covering the constitutional articles of India, the articles of one of the lengthiest and one of the most organic constitutions in the history of the world. Today we are starting with the Union and its territory. Myself, Navjot Singh, and I am a former officer of Intelligence Bureau. So see the Constitution of India. It came into being on 26 November 1949, but we adopted it eventually on the 26th of January 1950 to give importance to the historic day of 26 January 1929, which was celebrated as the day that marked the first Independence Day or the Purna Swaraj Day in the annals of Indian history. So, the Honorable Supreme Court remains the guarantor and the protector of the fundamental rights of the citizens and is the bulwark of Indian constitutional scheme. So in this 360-second series, we'll be trying to understand and unravel and demystify various articles of the Indian Constitution and also highlight the important judgments and standpoints that stand there too. Let's start, friends. So first of all, let's go about talking about Articles 1 and 4. Articles 1 to 4. So Article 1 to 4, they come under the Part 1 of the Constitution, and it deals with Union and its territories. So India as a union and its territories. So Article 1 it states that India, that is Bharat, both are the names of our country. It is a union of states. India, that is Bharat, is a union of states. And this provision, particularly in the Article 1, it provides with two things. Number one, the name of the country, that is India and Bharat, and type of polity. All right, it is a union of states. It's a democratic system. So one thing we need to understand here is it is neither an agreement between the states nor the states have the right to secede. So as in case of the American Constitution, American federal system, it is a indestructible union of indestructible states. But in our case, we are an indestructible union of destructible states. So it is not a result of an agreement. It is a union. It is a union between the constituent parts. Okay. So that, as we said, we are an indestructible union of destructible states. States can be destroyed, they can be reorganized, but the sanctity, the integrity, the sovereignty of the Indian Union remains intact. That is, it is sacrosanct. The integrity of the Indian Union is sacrosanct. Okay. So Article 1, it mentions the territory of India, which consists of the territory of the states, the union territories, and the territories that may be acquired in the future. So it basically, you have to understand when we talk about the territory of India. Firstly, it constitutes the territory of states. Next, the union territories, which are directly administered by the center, and some territories that may be acquired later on. For example, at the time of independence or the time of writing of the Constitution, Pondicherry and some other UTs which were not a part of India but were later included. So the provisions of the Constitution are also to apply to those constituent parts. Okay. See, let's move on to the next article, Article 2. So Article 2 of the Constitution, it provides two powers to the Parliament. Number one, the power to admit new states into the Union of India. That is, adding new states which were not already part of India, and the power to establish new states. All right. Next on, it has the power of admission or establishment of new states not already a part. So there are three aspects to it. The first one, it talks about the power to admit new states. All right. Then to re-establish the states that are already existent, उनको हमें change करना है. And finally, the admission of states already not a part. For example, you can talk about Pondicherry here again. Okay, moving on. Article 3. Article 3, it talks about the internal readjustment of the territories of the existing states of the Indian Union. For example, we had the reorganization of Jammu and Kashmir. We had the reorganization of UP, Bihar, as well as MP, and till very recently, Telangana being made out of Andhra Pradesh. So that is what is called internal reorganization of states. That is a part of Article 3. Okay. Also, let's see what are the main components, what are the main impacts of Article 3. So firstly, Article 3, it allows for increasing the area of any state. All right. It also diminishes the area of any state. For example, of Jammu and Kashmir in very recent history, then it can alter the name or the boundaries of the states. For example, we can talk about Madhya Pradesh, and it forms a new state by altering territory of 2 or more states. So 2 or more states can be included in that, or maybe some parts of different states. So all this comes under the ambit of Article 3 of the Indian Constitution. So there are 2 important conditions that we need to remember as far as Article 3 is concerned. Number 1, a bill to be introduced in the Parliament only with the prior recommendation of the President. So any bill that seeks to change the internal territorial integrity of India has to come with the prior recommendation of the Honorable President. Also, the bill needs to be referred to the concerned state legislature. One more thing that we need to note here is the President is not bound by the advice of the state legislature. It is only a constitutional practice and he's not bound by that advice. Okay, thus it becomes pertinent to mention here that the territorial integrity of a state is not guaranteed. That a state can be destroyed, it can be readjusted, it can be made a part of another state. And India, it is an indestructible union of destructible states, as we have already mentioned. Laws under Article 2 and 3, they are not to be treated as amendments. So they don't come under the ambit of constitutional amendments under Article 368, which provides for the procedure for amendment. So laws under Article 2 and 3, they don't account for as constitutional amendments to the Constitution. Okay. Another important thing that we can note down here is, as per the Birowari Union case, Indian territory can be ceded to a foreign country only by amending the Constitution under Article 368. So we have to understand the importance of the Birowari Union case. So what was the context here? Why the 97th Constitutional 9th Constitutional Amendment Act of 1960. So it would transfer the Birowari Union in West Bengal to Pakistan. So that was the case. So it needed an amendment. You cannot cede a part of a territory of India to a foreign country without amending the Constitution. So likewise, 9th Constitutional Amendment came into being, and Birowari Union, part of West Bengal state, was transferred to the erstwhile Pakistan, East Pakistan, now Bangladesh. Okay, so Supreme Court, Honorable Supreme Court, it ruled in 1969 that a boundary dispute can be resolved by an executive action. For example, we have had seen the exchange of enclaves, We have seen the exchange of enclaves between India and Bangladesh. So such changes, such boundary disputes can be resolved by executive action, and there is no need of any constitutional amendment. So that's about it, friends. So that is about it. I hope you're able to get a drift about the important articles that deal with the reorganization of states and the definition of India as a Union of States, India that is Bharat, and how the nature of states is is not sacrosanct. The territory of states is not sacrosanct. It can be altered. And overall, the Indian Union as such is an entity is indestructible. So that's all for today, friends. I hope you're able to understand a few tidbits, a few nitty-gritties of the Indian Union. Thank you so much, friends. Jai Hind.